I'm Dr. Barry, licensed psychologist, and here we talk about true crime and psychology. Thank you so much for joining. Let's hop right into today's topic. Let's go.
Welcome. Thank you all so much for being here today. I wanted to talk about the Kouri Richins pretrial hearing. That this just happened this past week. And while I was watching, the things that stood out to me was talking about the pathways to violence. And there were two experts that had different opinions on the validity or reliability of that particular model. And so we are going to break that down and we're going to take a look at the model. And the state might use, if they did decide to use this expert, and I'm sure the expert will be prepared too with different research studies, because the one expert that said nobody uses this, if you Google it, there seems to be some contradicting evidence. Now, I think the expert for the defense, she strongly feels that it's way too general of a model, and she's not a fan of it at all. And she made that very clear during her testimony. I also want to talk about Kouri Richins' behavior during the state's expert's testimony, because she was a lot more playful than I think we've ever seen her. And so I will definitely be taking a look at that. And I saw Emily D. Baker cover this as well. Thank you all so much for being here. And but the defense is just trying to do their job. So remember, anytime we start to get upset with the defense, because the judge made sure that things were fair on both sides, I think. And so we might play a little of what the judge said as well. So I think the state, and even the judge says, the state will not call this witness unless the defense, if their defense is mothers don't do this to the father of their children, or if the defense is, well, she, like there was no evidence that she ever, I don't know, like, so it's a very specific situation where this expert would even come in. I agree. I don't think the expert's going to come in, but if the defense opens the door, the state is prepared. And I think it's important to be prepared no matter what, because I think the state, because they even have a IPV, so intimate partner, they have a expert on hold just in case they need to explain why the victim stayed in the relationship when there may have been very clear signs that she was trying to harm him. It reminds me of the case out of Australia, except for that woman ended up harming her ex-husband's family. She kept poisoning him, and he just kept thinking like it must be something else. Like, I think he really didn't want to believe that she was capable of that. And I think it was Emily D. Baker, or there were a few other people that I heard talk about this, that just talked about how bad we are at predicting whether someone will or will not do something, which can sometimes make people feel a little less safe. But my goal for talking about it is um, to make sure that things are handled in an appropriate way. And so, Sarah, this is a legal question. And so I don't know the answer to this. It might have been covered on one of the other streams. All right. Because I know I saw EDB cover it. I'm pretty sure there were other people that covered it as well. I heard that Kouri's mother might have an attorney. I don't know if that's true. I just saw that as something that popped up. All right. So let's go ahead and dive into the defense expert, because they have somebody that they want to call if the state gets to call their witness. So for anybody that doesn't know anything about this case, Kouri Richins is going on trial for the death of her husband back in, my research says, 2022. She was arrested in 2023. She wrote a children's book And there is footage of her going on her local TV station and talking about helping kids grieve, which is really, so if she's convicted of this, because remember, people are innocent until found guilty. If she is convicted of this, to like, ugly, that's just sick. But they're outside of what happened. There seem to be some financial issues. The word that comes to my mind is scam, but there seem to be some property issues, financial issues. There was a lot going on in this case, and there are allegations that she poisoned him using fentanyl. And so I don't want to say it too loud because that's probably a word that the tube does not like. Um, and so let's go on ahead and hop in. I know there's some playoff games starting later today. My husband, I think it's 4:30 Eastern. My husband will be watching some of those. I will be back to watching more of my K-dramas after I finish up here. I did a short video because somebody asked, how do you manage your mental health as you're watching cases? And so I did a video talking about that. Let me queue up where we're starting, 27:48. So if you want to go back, because we are only going to play portions of this, we are not going to play all of this testimony. So this is the defense expert that is going to talk about why she does not believe that the pathways to violence model, that it is an appropriate model to be used in, court, anybody? I don't know. She's not a fan at all.
Criminology.
And so I don't know what's going on with my layout today because my sound is not coming. So we're having technical difficulties. Of course we are. I love when Emily D. Baker says, we are professionals. I am a professional psychologist. I am not a professional streamer. And so sound, and then let's make sure the output is coming through here. Okay. Now it should work the right way. Let me know if y'all can't hear something, okay? So we are starting with the defense expert, who is not a fan of the pathways to violence model.
To develop developmental psychology. So my goal is to actually try to create more established and evidence-based risk factors, trying to understand the development of offending. Again, this is an area that we're really lacking in, so there's plenty of opportunity for that science and data-driven research.
Okay. And do you have experience in violence risk assessment or threat assessment?
Yes, I do. I have extensive experience in both violence risk assessment and threat assessment in my academic research. Obviously, I also get federal grants. I work a lot with the U.S. National Institute of Justice. I have applied professional experience working with law enforcement agencies.
Somebody said echo. Grr. Okay. Let me try to see if I can fix it on my end. I did also plug in my what's it called? I plugged in directly to my internet. And so hopefully that will stop the freezing. Today is one of those fun technology days. So let me go to settings. Let's see. Let's do this one. Okay. So hopefully this one is better. And then let me just check my sound. Checking in 2 places. Thank y'all for being patient with this. All right. Input. All right. So let's see. Let me know if the echo is gone. Okay. If the echo isn't gone, I can talk about this without having to play the court feed. I can't stand the echo. So please know I will not play it with the echo if there's still an echo.
this was mentioned before this, but there is a distinction between investigative efforts and then obviously applied efforts, in a legal setting. I would say that my experience as a FBI special agent and of course as a research fellow in the FBI's behavioral science unit, where I evaluated and then try to help improve the scientific validity of both profiling and threat indicators, is what really motivated me as a researcher, kind of trying to take that old school approach and modernize it, and really trying to assess the reliability and validity of violence risk assessment, as well as these theories of behavior. That's where I won the early career award in specifically my work on developing theory on why people become offenders.
All right. And you heard us talk in court about the different standards and rules. And have you familiarized yourself with the Utah standard in addition to the federal standard?
Yes, I have read about the Utah Rule of Evidence 702. I have testified as an expert in other cases, so I'm familiar with the federal rules of evidence. And I do understand as well just how to evaluate scientific merit and reliability. I was the editor of our field's premier journal, Justice Quarterly. So as a journal editor, it was my literal task to assess scientific merit and how we can really understand, is this a credible theory? Not every theory gets published just because it is a theory. It really has to meet certain standards.
Is there any objection to certifying that she is an expert in this particular area?
Nobody said he isn't.
Okay, just wanted to make sure as we move forward. All right, so are you familiar with the pathway to violence model?
Yes, I am.
And can you describe what that model proposes, just generally?
Yeah, so the pathway to violence model is a group-based descriptive framework. It outlines a sequence or phases of behaviors that are thought of being observed retrospectively among individuals. It's really applied almost exclusively to individuals that commit targeted acts of violence like mass shootings or terrorist attacks. To be clear, it is not a diagnostic tool. It is not a validated risk assessment tool, and it cannot be applied to individual cases. It was not created using data. It has no scientific testing or reliability. It is pure theory, and it was postulated by individuals that, frankly, I don't want this to sound mean, but they have no scientific training.
All right.
Wow. So she believes, she has very, very strong beliefs, very, very strong. And she came off pretty, I think she stated her thoughts and opinions strongly. I do think a jury would likely find her credible and they would likely listen to her. And so let's pause for a moment and take a look at what the pathways to violence model is. Okay. And I shared, and whoopsie. Let me see if I'm doing the right thing. There we go. I have a link to all of this down in the description. And this is from violencepreventiontraining.org. So I'm guessing this is a community training. This is a training that's offered. And they do train on this pathway. And so they talk about reviewing specific behaviors you should pay attention to when interacting with others. And so it starts with a grievance, hostile, sarcastic, or bitter speech, sketches, writing, stares, or demeanor. It can then escalate to harmful ideation or thoughts. Grievance spawns thoughts or fantasies of the capital M. Research and planning, tactics and targets researched, attack planned, preparation, materials gathered, friends forewarned, things like that. Probing and breaching, and then that there is some harm that happens. And this site breaks down each one of those stages even more. I also just wanted to mention that the cybersecurity. So this is CISA.gov. So this is a government website, and it's Cybersecurity and Infrastructure Security Agency. And they have a publication on pathway to violence, and that there is this fact sheet and video that provides information regarding behavior and indicators that some people may demonstrate before some type of harm. And this expert, so the state does not plan, and the state went on to describe that later, that they weren't planning to use this expert or to talk about their expert in a way that says, hold on, yes. Thank you. He was in a closed door. I guess I'm talking too loud. They are also, he wants to be able to he's about to play games with dad. Him and dad are about to play Minecraft together. Thank you for allowing me to parent. So the state is only going to bring this in if there is some general statement that mothers don't do this. So this model does not apply directly to Kouri. And so they're not trying to say Kouri did this and then she did this and then she did this and this predicts that she did the thing. Like, they're not trying to use it in that way. It's just more of a general way to say, yes, there are some there is like, people have researched, and there is this this larger model. I wanted to take a look. So before we listen to the cat research talk, because that is the part that Kouri starts laughing. Okay, so I don't think she was prepared for the woman to start talking about redirected or aggression in cats, but that is what came up, and that was, and I went back and I watched it again, and it looks like her attorney said something to her, and then that's when Kouri started like laughing, and she kind of had to, I don't even want to say pull it together, but yeah. So that's when that happened. And so with this model, so a cat is experiencing intense emotional response, fear, frustration to a trigger, and then being unable to reach it, then redirecting that aggression towards the nearest available target, usually an owner or another household cat. So that was a part of that. Fear often linked to sound phobias and stressful environments. So a part of this research came out of researching cats, I guess. But like, that's going to come up in the next part of the testimony. All right. And so let me go on ahead and tee up the next part. All right. So the defense's expert does not like this model, does not feel that anybody should ever use it. She does not believe, but it wasn't trying to be used in a way to say Kouri did this. It was being used in more of a general way if the defense opens that door. And so all the defense has to do is not open that door, and it'll be fun. All right. So here is where the state's expert is going to explain her thing.
Ms. Amon, I don't think we need to go through all of the steps of the pathway to violence. I think the court has the generalized view of it, but what I would like to ask you are a few questions about how this model was developed, and we'll start there.
Sure. So in terms of how the model was developed, you'd have to, I guess, go back. The scientific research leading up to where we are now started about 100 years ago, give or take, when researchers began studying aggression in mammals. Specifically, cats were the sort of the origin story of this line of research. And researchers noticed two distinct patterns of aggression in cats, depending on the circumstances. In some studies, cats were presented with a threatening stimulus, a very threatening stimulus. And in those cases, they demonstrated intense autonomic arousal. So arched back, fluffed tail, hair along the midline, standing on end, that's called.
Okay. So I am listening to what the expert is saying, but I'm also watching Kouri as well. And so she was having some conversation with the gentleman sitting beside her, and then that's when she starts to laugh about something. Uh and and so the whole cat thing, that's why I wanted to go back and look at where some of that research started, because then I think the model continued to develop. And so there is a pathway to violence in cats, and then they studied pathways to violence in humans. So they looked at pathways to violence in animal behavior, and then they looked at it in humans. So what are the things that lead up to an animal reacting in that way? What are the things that can potentially lead up to a human doing something like that? And I also want to point out that just because somebody starts in one of those areas does not mean that they're always going to act on those thoughts. And that's where interventions, that things can come along to kind of stop things along the way, which comes up later in her testimony. We aren't going to listen to all of it. Okay. I think Kouri is going to continue to like I just thought it was interesting, and I don't know if she's going to do that in front of the jury. Like if she will have these types of reactions in front of the jury too.
Piloerection, back ears, they vocalized, such as hissing and growling, fangs out, claws bared, the whole show. You can sort of think of it as that classic Halloween decoration of the scaredy cat with arched back and all that. And they very quickly lashed out with an emotionally charged and relatively uncontrolled attack with paws and claws. And that was labeled affective violence. Affective for the psychological term affect, meaning sort of the state of thinking or emoting or feeling emotions. And then in other studies, the cats were presented with prey, like a mouse. And that was a totally different story. The cats were low to the ground, completely silent. Ears, instead of pinned back, they were open to localized sound, and the cats would inch forward.
So the laughing is going to continue right here. If you're listening and watching Kouri, the laughing gets a little bit is going to continue right here.
And they appeared to be planning and carrying out an attack at the moment of their choosing, typically with a bite to the neck or head, a very efficient biting attack that ended the fight before it began. And over the next several decades, that line of research expanded to other mammals, including humans. And what they discovered was that not only do these behavioral patterns hold true in humans, but they're also biologically distinct from one another. And the understanding came now that affective violence, so that reactive attack, is triggered by lower brain structures in the limbic system, triggering an intense autonomic arousal, as I've discussed, usually accompanied by intense fear or anger, and a cascade of hormones, all culminating in sudden physical defense against imminent threat, which could be real or perceived. It could be an internalized threat. And the evolutionary basis for that in humans is survival.
Okay. So I wanted to talk about this part, because mostly about Kouri's behavior during this part. I think she doesn't respect this expert at all and thinks that this is, I don't know, like it just, to me, it just came across, and her team doesn't either. Like her team didn't really, because when the team goes up to cross examine, they are going to focus on the cat thing, and that they believe there isn't empirical evidence. But if I just do a Google Scholar search of pathways to violence model, there, so I'm not clicking on all of these to see exactly what there is, but it does seem like this is something that is discussed and is in peer-reviewed journals, because they kind of made it sound like this isn't something that's ever mentioned in any scientific journal. Now, it's not a predictive model, so it's not saying that, yes, every person that starts on this path, that they're going to do this. But I also wouldn't go as far as to say that, like, there is no evidence to show this at all. And yeah, her behavior, it was just, and it came off a little immature to me, but but the jury isn't there. And there were times in other trials where I thought the defendant was showing a little too much emotion, or like I've had thoughts about other defendants' behavior. It was just interesting to see. And I do think that first expert feels that it's more of a pseudoscience than a like hard science. And but the state isn't trying to say that this is direct evidence that Kouri did something. They're only going to introduce this if the defense gets up and makes some general claim to try to sway the jury that, you know, no mother would ever. Now, if they say like Kouri wouldn't, that's different. But if they try to make this broad general statement, that's where the state may be able to bring in this expert. Okay. So let's see. I didn't plan, but let's look at just a little bit of the initial cross. So we'll just watch this part. The defense gets to cross-examine this expert.
Just a moment. Good morning, Ms. Amon.
Good morning.
So, Ms. Shermanek asked you how the model was developed, and you told us about cat research, but I didn't hear an answer as to how the model was actually developed.
Sure. So in the 80s or 90s, a number of studies were conducted on attacks against public figures, political figures, judges, other people. And in those studies, it became quite clear that the offenders were typically engaging in a sequential and recognizable cascade of behaviors leading to the violent attack. And so that became the pathway to violence. The data collected from those studies showed that 6 particular discrete stages were happening in virtually every case that was studied back at that time.
All right. And so I thought the expert did a good job handling that. Peachy Keen asked a good question, asked how would I describe her behavior and attitude? And so I don't want to use one moment to describe, because I already have some thoughts about her in general, just based on so this isn't one that I'm going in completely blind, because we've heard some of the evidence, we've seen some of the things. Now the jury needs to have an open mind, and they need to believe that, you know, people are innocent until proven guilty. Like that's how the jury has to come in. I'll be honest. I try to be honest anytime I do have potential bias in a case. I personally feel that, but like not just based on what we've seen and heard, and my mind can be changed when I follow cases, but she seems kind of guilty to me personally, but that's just to me. I don't know if that's true. Okay. Those are just my thoughts and opinions. So I have to be aware that when looking at someone's behavior, if I thought the defendant was innocent, would I view their behavior different? And because I thought there were times that, because I thought the case against Karen Reed, I thought the investigation was horrible. I did not think they had enough evidence to convict her of what she was acquitted of. But sometimes her behavior in court was a little interesting. I'll leave it there. So I already have some thoughts about her, and so that's why I'm careful when I answer questions like that. I hope that's helpful. All right. Let's see. So now we are going to skip ahead to the judge. Okay. So the judge is going to make a ruling. I like this judge. I know some people weren't happy that he closed the hearing because there was a day 2. And so they're really holding, because they were going to present certain evidence, and they want to make sure to not taint the jury pool. They want to make sure that the jury does not hear evidence before they're on the jury, because the juror surveys have already went out. And so that's why they decided to not allow cameras into day 2, because they were going to review specific testimony. And I can respect that, but all right. So the judge is going to make his ruling here.
To in any matter, I think is inappropriate.
Okay. All right. All right, the issue before the court is whether Ms. Amon's proffered expert testimony should be excluded in its entirety. The motion is made under Rules 702 and 403 of the Utah Rules of Evidence. The court addresses Rule 702B first. It provides that scientific, technical, or other specialized knowledge may serve as the basis for expert testimony only if there is a threshold showing that the principles or methods that are underlying in the testimony are reliable, are based upon sufficient facts or data, and have been reliably applied to the facts. Here, first, it bears noting that Ms. Amon is being offered as a blind expert. She is speaking about general principles, not applying a framework or analysis to the specific facts of this case. Moreover, her testimony is based upon a retrospective study of killings that actually occurred. And based upon that retrospective study, her testimony identifies some commonalities that exist among completed killings, while also acknowledging that people that begin on the so-called pathway to violence often fall off at any of the stages, sometimes begin again and then fall off again. That just because they begin on the pathway does not predict or mean that they will complete a killing. Under Rule 702A, the court finds that based upon her education, training, and experience, as shown in her CV, Ms. Amon is qualified as an expert in this field.
So this comment here says the judge is stating the obvious. And I personally think he's just making a thorough record, because he's about to allow this testimony in a specific case. And so I think all that he's saying here is for the record and for any potential appeal if she is convicted. So I think that's what this judge is doing now. And yes, I agree, Sarah. He's been very thorough, and I appreciate that, especially seeing other cases where cases have been overturned and things. Yeah. Yes. Yeah. And so I did try to make sure to say Karen Reed versus Kouri Richins, but yeah. I'm not great with initials anyway, so I normally try to at least use the first name when possible, but it is what it is.
And the court finds that her testimony based upon that retrospective study is sufficiently reliable and based upon a sufficient set of facts or data, given her description of those retrospective studies and their updates over time, to satisfy the minimal threshold for reliability under Rule 702B for a blind expert. The real issue is whether her testimony would be helpful to the trier of fact under Rule 702A, and under what circumstances. To be clear, under cases like
and so he's going to make this extremely clear. And that's why I want to play this part, because he's making it extremely clear to the state and the defense what would make him rule for it to come in or not come in based on the law and everything.
United States versus Wells, 879 F. 3rd 900, which is from the Ninth Circuit in 2018. Ms. Amon's testimony cannot be used by the state in its case in chief as substantive evidence of guilt. And even if she's called as a rebuttal expert, the state cannot refer to her expert testimony as a basis for the jury to draw comparisons that would weigh in favor of a substantive finding of guilt. However, in the event that the defense makes an assertion in its defense case that is categorical and general, for example, something to the effect of that it's simply not credible that a person would engage in a weeks-long campaign to kill another person in the absence of an imminent threat to their safety, then Ms. Amon's testimony regarding the retrospective study of completed killings showing a feature such as a preparation and plan over time would be helpful to the trier of fact under Rule 702A to rebut that generalized categorical assertion by the defense. If the defense makes an assertion to the effect of Kouri Richins did not commit these crimes, and one of the reasons you can be sure of that is because Kouri Richins had so much to lose in her personal life and her family life if she had, that is a case-specific level that Ms. Amon's testimony would not be helpful in rebutting. However, if the defense makes a absolute or generalized categorical statement regarding how homicide unfolds or whether it ever unfolds as alleged in this case, Ms. Amon's testimony would be helpful to the trial of fact in rebuttal.
All right. And so that was the gist of what he said. If you weren't able to see it, Emily D. Baker did a great job covering it. And I know some other people covered it as well. They did talk about a handwriting expert and whether or not that might come in. And then they also discussed a IPV expert, because there is a chance that, depending, I think, on what type of evidence because let's say the defense tries to say they were this happy, loving couple. There were no warning signs. There were no issues. That's where, because the judge asked the state, was there any history of DV? And I think the state focused on physical and not looking at emotional, verbal, other types. Those are often the ones that are more difficult to prove. But because when asked that direct statement, the state did say no, that they did not have evidence of prior to his death, that specific day, because it does seem, because that's where it was just weird, because I would think attempting to poison someone multiple times, like, I would think that would count as a potential, like, act. But I think because she hasn't been convicted of that, I don't know. So that's where I don't know the state's thinking. I think they were just trying to be very clear in what they were saying did and didn't happen. There definitely there seemed to be issues with money. There seemed to be a lot of secrets. There seemed to be a lot going on. And the victim in this case, he probably was just looking at his kids, looking at everybody around him, and he probably loved her and wanted to try to make it work. He might have thought that she would have never done something like this to him. And it's just really sad that this is where things are, because there are children that are now without their father. Their mother isn't physically there. And depending on what happens, that'll kind of determine what happens with their relationship with them. But with the reasons why sometimes it can be difficult to leave a toxic situation is there can be fear of abandonment. There can be a lack of support from family and friends. That does not seem to be present in this case. I'm just speaking in general, what can sometimes be present. Sometimes there can also be this feeling of not wanting to have been duped, because sometimes what can happen when a person realizes, oh my gosh, this other person really, this is a toxic situation, this is not healthy, this really isn't a healthy love, this isn't a healthy relationship, they can feel duped. They can feel like they've wasted their time, they've wasted emotions, energy, or like this person isn't who they really thought they were. And that can be really difficult to all bring together. And sometimes there can be this dissociation or disconnection of what the victim is experiencing and what they originally, like that idea that they had for their life, for their marriage, for their family. It can be hard to just realize, oh my gosh, like this really isn't healthy. This really isn't going to go the way I thought it was going to be. And so I don't know exactly what that expert might say if they do come up, but I did think it was interesting that the state has somebody on board for that. And then you all are mentioning in the chat children, because often concern for the kids, wanting the kids to be in their parents' life. When people do separate or divorce, it changes the kids' lives. It does make things a little bit more difficult. I wonder what evidence will be there, because digital evidence can sometimes go a long way, and so we will see. But I'm really am interested to see what comes out in this case. I will be following this trial. I also wanted to give an update that we talked about the Devin Michaels. Devin Michaels, also known as Nikki. I think she was also known as like Tracy. She's known as multiple different things, but she could have served, what's the word? She could have served a sentence that was a lot shorter, because she had a deal. Okay. So I covered this case. If you know nothing about this case, it's very sad. It's so this woman here, her name is Devin Michaels. She had a deal with the state to plead guilty to, I think, either manslaughter or second degree capital M, but she was only going to get 15 years. She was only going to get 15 years. And then at her sentencing, she was going to be sentenced. The victims were all there ready to make their statement to the judge. That day, she decides to say that she felt duped into signing it, or agreeing to it. She really wants a trial. Somebody else did this. It wasn't her. And so the state was like, Judge, we're not comfortable moving forward. And she ended up going to trial. A jury took like a few hours. They didn't take long. They ended up convicting her. This case, a bunch of family secrets, because when I first heard about the trial, the case, I wasn't aware that Devin Michaels, so she was convicted of unaliving her children's father. But at the time of that, she was married to her husband's son, technically her stepson. So she married her stepson, and all of these things came out during this. She's kind of tried to blame him for what happened, but there's digital evidence, and there's evidence that says, because all the evidence points towards her. There was nothing that pointed towards him, but that's what she did. She decided to point the finger towards him. So she ends up getting convicted, and she will now serve. She ended up getting more time than she would have. I thought it was 28 years, but okay, sentenced to 20 years to life with an additional 8 to 20 years. Yes, for capital M with a deadly weapon. And she'll get 2 years credit for time served. Okay. So that case was wow. And then Sarah asked the question, are most criminals ego-driven in personality? So I try to focus more on the clinical and treatment and some of those aspects of things. I am not an expert in in criminology or why people do these things. That is, I like to talk about how the victims can heal, how we can take a look at these cases, how we can break down any mental health things. Because I think most people are ego driven in some way, but criminals, what they add is this lack of concern for empathy, or this lack where their needs trump other people's needs, or what they want trumps what other people want, and that willingness to violate somebody else's rights. That's where those things can come up. I'm also following the Nick Reiner case. His defense attorney stepped down at his most recent arraignment. There's a lot of speculation. We don't know for sure, because it would go against client lawyer confidentiality. But what likely happened is maybe the family isn't supporting him financially anymore. And so he's been assigned a public defender. I am watching to see if they raise competency at any point, because there were some. So I don't know if it's true, but if his behavior is erratic, or he may be getting services behind bars for mental health, because people can be on medication. His behavior during the hearing was fine. So there were no red flags during that hearing. He was completely appropriate. But I am just watching to see if anything comes up with that case too. All right. And so welcome to everyone. This upcoming week, so I go live on Tuesdays and Saturdays. And so we will see what things come up this week. And I will see you all on Tuesday and Saturday. I hope you all enjoy the rest of your day. Spend time with your family. Yeah, it's raining in Virginia. Like, our weather is not great to be outside, but connect with the people in your lives. And I hope you all have a great rest of your day. All right. Bye.